Good morning, everyone. Let me call our 30th public meeting of the Post Commission to order. I'm the chair of the commission. My name is Margaret Hinkle. Let me at this time indicate what members of the commission are present. I will call on each of them to indicate their presence. Let me start with Mr. Bluestone. Commissioner Calderon.
Present. Good morning, everyone.
Commissioner Sherry.
Present.
Commissioner Ellison.
Present.
Commissioner Kazarosian.
Present. Good morning.
Commissioner Luma.
Good morning, present.
Commissioner West.
Good morning, present.
Commissioner Wynn.
Good morning, present.
Thank you. Each of the 9 commissioners is in attendance. Moving to the items on the agenda, let me ask for a motion to approve the minutes of our last meeting, the October 13th, 2022 meeting. Is there such a motion?
So moved.
Is there a second to that motion?
I second.
Questions or comments about the minutes? I see no hands in the air. Let's have a vote on the motion. Commissioner Bluestone, please.
I approve.
Commissioner Calderon.
Approved.
Commissioner Sherry.
Approved.
Commissioner Ellison.
Approved.
Commissioner Kazarosian.
Approve.
And Commissioner Luma.
Approved.
Commissioner West.
Approved.
Commissioner Wynn.
Approved.
I also approve. The minutes are unanimously approved. Moving on to item number 3 on the agenda, the executive director report. Enrique, please.
Thank you, Madam Chair, and good morning, Madam Chair and Commissioners. Just a quick housekeeping note, just a reminder to those members of the public in attendance that even though we have the Q&A function enabled in our technology platform here, we will not be taking questions live or have members of the public provide comments. They can still submit questions using that function, especially if there are any kind of technical difficulties. And we continue to respond to questions that are submitted to us by email or by phone, which can be done at any time. Let me get into my report, Madam Chair. And as customary, I have a PowerPoint presentation that is in the packet, but I'll share with you momentarily. And I suppose everybody can see this. And let me just begin my report saying that we continue to make progress on multiple fronts. We do the certification of new graduates, recertification of individuals with last name A through H in the last stages. I'm going to get into that in a few minutes. We are formulating a process to validate disciplinary records from agencies. That's a big project that continues. We continue to receive complaints from the public and from the public via agencies, and I will be demonstrating a new web-based public complaint form in a few minutes. And we, of course, continue to build the regulatory framework, technology, that is going to enable us to report on all the information that we're required to do. So I want to briefly summarize the recertification process that commissioners are familiar with, but I think it bears repeating that we ensure compliance with the requirements of the statute and focus on individuals without a positive attestation of good moral character and fitness for employment from their chief. Those individuals, or rather the first step is the first level of review is the division of certification that focuses on those with a negative attestation. And in conjunction with the division of standards, they review for compliance with those regulations. The division of certification can then issue a determination, and the individual officer can request reconsideration. The second level of review is myself, the executive director, as it's stipulated in our regulations. And that review can be done on documents, or I can be in a position to request additional information, including perhaps even an oral interview. This review is then followed by a potential review by the commission in instances where there continues to be a finding other than full certification. Some cases that may fall in this category will eventually come before you or a hearing officer as the chair might decide to implement. Going forward, individuals that fall in this category, numbers 2 and number 3, these categories, will be reported as those falling in the potential inquiry or hearing category. Another update in terms of recertification reporting pertains to individuals out on leave. This includes instances of administrative, injury, or military leave. And given that most of these cases, those individuals have not complied with the requirements of the statute, we have classified them as not certified on leave, and their certification is essentially stayed or effectively on hold. We believe that this is the most appropriate designation at this point. These individuals will have an opportunity to demonstrate compliance with the requirements of the statute within 90 days of their return. But they must advise post of such date to be able for us to track their compliance. One reason we're taking this step is to ensure that we can track when these officers return to active duty. They come at, of course, at very different times. And given that in the past, they were not notifying us, we were having a real hard time tracking those dates, especially when it comes to coordinating the requirements of compliance with the requirements of the statute with our sister agency, the NPTC, and hence this classification. So I will go into this next slide, which is slightly, it has a couple of some different numbers from what I have been reporting in the past. You will notice, commissioners, that we no longer have and are phasing out the category of further review. We feel we have done, we have a good handle on a review of all applications for certification submitted. And we are beginning to report a group of individuals who are perhaps part of a preliminary inquiry or suspension. I have side by side the last time I reported the numbers and what we are reporting today. Those 12 individuals with the first asterisk are, if the commission later in the meeting accepts or approves certain suspensions or preliminary inquiries, these individuals are in that category. You can see the increase in individuals now in the not certified category, which is explained here on the side. And of those 243 individuals, 133 are out on leave for the reasons that I just explained a few moments ago. Those individuals, we can reasonably expect that if and when they return to active duty, they will have the 90 days to comply with the requirements of the statute, the oral interview, the attestation, or etc. 63 individuals that at the time submitted an application for certification failed the Bridge Academy, perhaps attended or never signed up, and we have to put them in the not certified category. Some, in fact, I understand at least 3 or 4 people of those 63 choose to go to full academy, and they can eventually come back into the certified category effectively once they complete the full-time academy. There are 21 individuals who retired or resigned since since those applications were submitted to us, given that we have a fairly large amount of individuals. There's going to be effectively a fair amount of people that rotate out of the system. And there's 26 at this point that may be part of a pending matter, including a disciplinary matter. And this includes instances where there's not an attestation by the chief, and the Division of Certification is affirming that determination of not a good moral character. Some of these individuals may choose to avail themselves of the 2 levels of review that I just explained a few moments ago, and may end up coming back into either the potential inquiry or hearing category, or before you for that final determination. What we had at the time a month ago in the prior meeting of 44 individuals that were pending validation ended up being a couple of duplicate certification applications, and we now are fairly certain that the total number we have from A through H is 8,846 individuals. I want to pause here and in case commissioners have a question on this slide, because this represents, of course, a slight change from the prior reporting. And I see there's already a couple of hands. Commissioner Bluestone, I believe you had some question.
Yes, thank you. I'm just looking at this language and wanted some clarification, because I see here, and I understand that the category further review is for individuals where we have not finished our review. It seems like, right? Is that correct?
Right.
And then we have the potential inquiry, hearing, suspension category, and in that category, as I understand it, one of the possibilities is that it would be individuals who are seeking an executive review, right? That there's been a designation and they're seeking a review by the executive director or a designee, right? So I'm just wondering about the potential inquiry language, because it sounds more disciplinary than a person being entitled to an executive review. And I'm just wondering what the potential inquiry means.
Yeah, our regulations speak to a preliminary inquiry being the action that the Division of Standards takes on a disciplinary matter that may come before you. We want to make sure that it's potential, because we don't want to presume that you'll authorize the start of that preliminary inquiry. Later in the meeting, if you approve to go into executive session, we have 6 requests to approve a preliminary inquiry, and if you choose to approve those, then we'll undertake it. So we want to emphasize the potential part of this category, because we don't want to assume one way or another. One could conceivably, to be fair to the first part of your question, Commissioner, just continue to report as further review, but we want to start clarifying that what was typically in the last few commission meetings, just our workload processing information, we now have a lot more certainty of where some of these categories fall, which are not necessarily final. And I think that's what's a big takeaway from this new category, this potential inquiry category. It's not yet final, but this is something that now goes through the pipeline.
So that's really the question I think I'm raising, is that when you look at that category of potential inquiry, hearing, and suspension, that language all sounds disciplinary to me. And I'm wondering if we also would consider that executive review, the number two, when the officer is seeking a review, to fall into that same categorization, or would that fall under the category of further review? And I'm just raising that question for people to consider.
We could report it separately if that's preferable, Commissioner. We can certainly do that.
It just seems to me that it's not at the same level of seriousness as perhaps some of the other steps that we might be taking.
Okay. We can think of the right terminology and then maybe report back, Commissioner, as a separate category.
Thank you.
Sure. Commissioner Ellison, do you have a question, sir?
Yes, I have two quick questions for you, really. What on the 12 individuals, the potential inquiry hearing session or hearing or suspension, have those notifications have they been notified of this status? And what is the time frame for them to respond to the notification?
If they have not been notified, assuming, because we will be seeking your approval for that designation. If you so approve, they will be notified as soon as practical, within a day or two. And there's, I believe, and maybe Randy can correct me if I'm wrong, there's a 30-day time frame for response from them. I'm sorry, there may be a 60-day time frame for us to conduct the preliminary inquiry, but they will have ample notice of that. Randy, did I get that right?
Yes, there's a period of time within which a report needs to be made. So that would be 60 days.
Okay. And my second question, on the officers that are out on leave or out injured, upon their return, who is it incumbent upon to notify the post of that date of return? Is that the department or the individual?
We lean on the departments, as being an easier way for us to communicate with them, but we'll take the update from either. We really prefer the department to let us know that they have come back, but we can also accept them notifying us themselves.
I guess my issue with that is that, because if you don't get an official notification from their department and it's delayed and you get it from the officer, and then the times are not lined up with the 90-day clock ticking, I'd rather have that from their department rather than from the officer putting that on them, or the official notification as far as the post. I'm not saying that you can't accept what they're saying, but then the notification from the department would make me feel more comfortable just covering that the department is on board with their return as well.
Okay, we will ensure that's our protocol, Commissioner.
Thank you.
I can move on unless there's other questions from commissioners. Okay, so I want to move on to the public complaint. I'm very happy to report that our public complaint web portal is now live and has been live for a few days. This form will enable us to capture structured data in a much more efficient way and generate better reporting. Our intention is to phase out a general mailbox that's here, post-C reports at mass.gov for public complaints. Agencies continue to use that when they send complaints to us. We're eventually going to also be phasing that out when we implement our and deploy our Salesforce, the technology solution that I talked about in the past. I will mention that there was great collaboration with the Technology Services Office of the Commonwealth, given that this form, the public complaint form, resides on mass.gov domain. There's a group who was quite interested in making sure that the user experience is consistent with the existing parameters. In other words, that we don't have too many words, or it doesn't sound too much about legalese, and that it's easy to understand, etc. That was a good process, and I think we have a good product. So when interacting in our website, this is the main part of our website. As you scroll down, there are now two boxes that are meant to triage and point members of the public in one direction to this public complaint form, and law enforcement agencies in the other way in which they have been doing from the beginning. So let me exit out of this and demonstrate fairly quickly. Once you click on the public complaint form, if you give me a few minutes, I'll demonstrate what happens. I don't know. I hope this is not a problem. Let me just go. Can everybody see this, commissioners? Yeah. So this is a public complaint form. We have, of course, instructions and disclaimers. These kind of disclaimers are consistent with other state agencies, notably the Attorney General complaint portals. We have to explain what happens when they submit a complaint, including how we are categorizing them. And of course, we have to advise members of the public that some of this information may eventually be a public record. And that's important to disclaim upfront and have the individuals acknowledge that they understand and agree. We ask for contact information. Well, we of course ask for the events. We use the conventions that everybody's accustomed to. The red asterisk means that it's a required field. We can have multiple, categorizations of those complaints. We accept file uploads, and those may be more than one file, and this could include video. We try to triage the severity of the complaint, as well as have a way to identify who they're complaining about. Notably, the most important required field here is the agency, and it's now structured data so that there's no miscategorization. People can just begin typing up the name of the agency here and it'll pop up. These could be referenced to multiple officers. And perhaps more importantly, somebody can submit a complaint on behalf of themselves or on behalf of someone else. And there could be multiple affected people or multiple witnesses. We clarified that we ask for contact information, which is not required, but we want to make sure that people understand that the Post Commission may not be able to reach individuals that don't provide information in case that is necessary. We also ask for actions that individuals may have taken already, which again is consistent with other forms like the Attorney General's office. And we just ask for a very simple, straightforward acknowledgement that what they are providing is true to the best of their knowledge. So this complaint, as I mentioned, and let me exit out of this and go back to my report. Sorry. We believe is going to allow us to to capture structured data in a very important way. Can I are there questions from the commissioners relative to this public complaint form, or can I continue?
May
Okay.
I ask, Enrique, may I ask what the basis is for not for permitting anonymity in the person as to the person making the complaint?
Yeah, the commissioners might remember that in our regulations, we stipulate that we will accept anonymous complaints so long as there is a basis for investigating them. There are instances one can imagine in which somebody may be reluctant to provide their name, but again, we have to allow for that possibility. I think allowing people to submit complaint on behalf of others is a great way to have both follow-up and anonymity if it's desired. But we felt that requiring a name was not necessarily all-encompassing. I see there's a couple of other questions. Commissioner West.
Thank you, Enrique. And my question is on the same subject matter. I think the complaint form looks great. In regard to anonymity, you know, there are other programs that allow people to submit a complaint and who do not want to give their identity because they have certain concerns. In particular, the SEC whistleblower program allows the person to do that, and they have an attorney submit the complaint, and thereby not revealing their identity, but still giving the agency a way to contact that person. I don't think we need to make any changes right now, but just offer that up, because I think there is a way to do this and still get contact information.
Yeah, that's right. I mean, this is a field, commissioners, that if you all thought it was generate more difficulties for post, we could make required. We debated quite a bit with people who feel that that needs to be a possibility. But you're right, we can look for alternatives. I see that Commissioner Bluestone had her hand up prior.
Yes, thanks. I think I just wanted to kind of acknowledge from my own experience just the tremendous effort. Well, first of all, you know, that the form as it's been designed, I think is just very well done, and I think we all probably need to recognize that it's a form that may need to evolve over time, but also that there is actually on the other end of this form people who are making tremendous efforts to respond, to listen to the complaints and the information carefully and to evaluate it. And like with any process, I think it's a wonderful step forward. And also, you know, it's come to our attention that there are complaints coming in that may fall into the category of false positives, as they probably do at the local level. And I just sort of wanted to acknowledge that I think as we go forward, we need to think about the fact that when the process goes forward and the person who is bringing the complaint is not presenting it in a respectful and appropriate way, that we need to follow up to think about how do we manage situations where people are complaining in a way that is disrespectful or threatening.
That's right, Commissioner. And I was going to touch on an aspect of what you just mentioned in the next slide, but that's correct. There's a small number of individuals who complain repeatedly, and I'll touch on that in the next slide. Commissioner Sherry, did you have a comment or question?
Yes, a question. Thank you for this presentation. My question is, what is the timeline from the public's complaint to receiving it and then to responding? that the complaint has been received?
Well, we're caught up with a lot of the complaints that have flown into that mailbox, so it's fairly quick turnaround. I will say that whenever somebody submits a complaint, they get an immediate acknowledgement that it's been successfully submitted, if that's the case. If there is, for example, an error, they didn't enter, for example, a field that is required, the form will immediately tell them that. But we try to coordinate with the law enforcement agencies, frankly, because of resources, Commissioner. Many of these complaints have already been submitted to the law enforcement agency, and they have 2 business days to submit them to post. So our hope with now structured data, the way that the reason why I'm very happy that this is a very good process in terms of making efficiencies, is that now we're able to report, aggregate, filter on complaints versus what may have been already submitted from the law enforcement agency, and ensure that somebody's investigating them. But we do follow up with people. We have 1 individual mostly in charge of this. We need more resources in this area, Commissioner. We need to assume that these complaints will probably increase. The numbers that I'm going to get into in a minute are going to increase. That people, the more they know us, they'll know that maybe we are an alternative to complaining about the police department that's not in the police department. So we need to plan to put additional resource in this because this is very resource intensive.
Thank you.
Commissioner Luma.
Yeah, I had a hard time hearing Commissioner West because of an echo, and I just wanted to paraphrase what was said so that I'm clear.
Thank you. Can you hear me now? I just put in a microphone.
Yes.
Yeah, I was just indicating that there are other agencies who have the same issue with anonymous people. And the way the SEC deals with this is they allow for a lawyer to submit a complaint if the person wants to remain anonymous. I'm just putting it out there as a consideration if the commission has an issue with people not revealing their name. That's all.
I'm glad that Commissioner Luma asked you to restate, Commissioner, because we do have that ability. Maybe I went through it very quickly, but we have the ability of this complaint to be filled out by somebody else. It doesn't have to be a lawyer. It simply can be, a friend or whomever else. And that contact information can be recorded. And it's a great way to kind of go back to if we need to ask additional questions or clarifications.
I mean, I would like to see a way that an individual can remain anonymous. I know there are concerns on the back end. However, I think there are people who just have significant concerns about coming forward in this way. And we have to allow them to have the opportunity to submit information while maintaining their anonymity. So I think, if it's for further discussion, then we can do that. But I'm concerned about community members who may not feel safe enough to do so.
Which is the way that currently the form operates, right? The field is not required. If I suppose a majority of the commissioners felt it was important for us to make it required, we could reconsider. I could get into numbers and continue to report numbers like this in the future, but we can see there's something I should mention here. Because this is now a web-based form, there's all kinds of Google Analytics that we will be able to track. For example, if somebody starts filling out information and they leave the page, they don't submit anything, we'll know that information. We'll, for example, see if there was a barrier of some kind. And that's also a very important part of the process, which I think is going to be very helpful. Okay, so let me, if I may, just keep going on a little bit more on the public complaint form. So even though we have just deployed this form, prior to this, members of the public were just using their general mailbox or our mail, our phone. And to date, we have received approximately 1,650 complaints. And this is a little bit of what Commissioner Bluestone was talking about. About a quarter of those complaints come from a very small group. That's about a dozen individuals. We, of course, anticipate that the new form will result in more complaints coming to us. But our approach is, of course, to treat all complaints seriously and interact with the public in a professional manner. I would note that some of the repeated complaints or the repeat complainers, sometimes it eventually becomes clear that some of these complaints are not credible for a variety of reasons. And we are documenting and making sure that we have consistent protocols for those responses. In many cases, it means contacting the law enforcement agency, and in some cases, it may include referring the individual to additional resources. I am not sure if this 25% or so ratio will be consistent in our future, or if that's consistent with other agencies or law enforcement agencies. But assuming that this ratio continues, we may seek forming partnerships with organizations that are trained in social work or mental health, because this is, as I mentioned, is resource intensive, but we just plan to acquire the right resources. Just briefly on the next slide, I want to quickly highlight that there's updated information on our website, including the ability to make public records requests, and that has been operational for a few weeks now. This is also going to allow us to capture structured data. We have the ability to sign up for post updates, and that's also an important part of keeping up with the public. Finally, I just want to briefly mention that Governor Baker signed the closeout supplemental budget, and that means that we have certainty that we can count on approximately $2.9 million of unspent monies from fiscal year 22, and that is the year that ended this past June, and use it on this fiscal year, which is very welcome. We certainly have the need. Our pace of expenditures has accelerated quite a bit, especially as we make additional hires and continue deploying the technology platform. We have rolled out an employee evaluation process. It includes 2.5% cost of living adjustment and proportional, of course, to the date of hire, and a merit rating system with an additional 1% or 2% depending on the employee evaluation. We welcomed Albert Fung as our business analyst and Chrissy Fitzpatrick as our paralegal within the Division of Certification. And they both have hit the ground running, which is great news for us. There's lots to do in those areas. We are currently hiring for a second paralegal for the legal department and a digital communications manager to continue interacting with the public in a way that is consistent with current times. We're currently 22 employees and are projecting that before the end of this fiscal year, we'll reach to 28. We'll be coming back on the coming months with our projection for the next budget in the next few months. I'll pause here with my report, commissioners, and can ask again if there's any questions or comments, and I'll stop sharing my my screen.
Enrique, I don't think I see any hands in the air. Let me echo Commissioner Bluestone's thanks and broaden it to all of the members of the staff who have worked incredibly hard and diligently in producing the information that you provided to us today. We certainly have some things that I think we have to take up again at future meetings, but I think you have provided us and the public with a great deal of very significant information.
Thank you, Madam Chair, and that concludes my report.
I think with that, let me move on to item number 4 in our agenda, which is our general counsel, Randall Ravitz. Update, please.
Thank you very much. The first item within this section of the agenda is a proposed set of regulations that I will show on the screen. Okay, this set of regulations would expand upon what the commission has already done in the area of certification. And these would govern any initial certification. So for example, those who have just graduated from an academy, as well as the certification of any officer who applies independently, that is without the endorsement of an employing agency, whether that officer seeks an initial certification or a renewed certification. And that category would include any constable. Now, at a presentation at the last commission meeting, I highlighted 4 issues regarding constables in particular that make their situation different as we confront the certification system. One is when and how constables are made subject to Chapter 6E, given that it extends to a constable executing an arrest for any reason. How we know, for example, who fits in that category. And one potential approach that was suggested at that time was providing for constables to affirmatively apply for recertification, at least where they seek the power to make arrests. A second issue is how the certification process for constables should proceed in light of their independence, the fact that they normally are not employed as a constable under a law enforcement agency. And so, for example, how would the background check process work? How would an oral interview administered by the commission be conducted? How would the character and fitness standard be evaluated? Those are all areas in which the commission has enlisted the help of employing agencies in the past. A third issue is ways in which constables can satisfy training requirements. And a fourth issue was the extent to which constables are subject to forms of oversight and consequences that are comparable to those provided for other officers in the statute and regulations. So this set of proposed regulations generally applies the same standards and processes that the commission adopted for the recertification process. And it takes into account documents that the commission previously approved for initial certifications. But with respect to independent applicants, again, those who are not endorsed by an employing law enforcement agency, including constables, these regulations provide that in order to satisfy the background check requirement, the applicant can either request that a law enforcement agency conduct one, for which the agency may charge a fee, or request that the commission conduct one, for which the commission would charge a fee. And that to administer an oral interview, the commission would arrange for the interview to be conducted by one of several approved individuals. So there are some possibilities listed down below, and may prescribe the asking of certain questions or the coverage of certain topics or the use of a questionnaire. And as to character and fitness, the commission would make an assessment based on certain information collected in the process and a set of guidelines provided below. And again, those are consistent with guidelines included in the recertification regulations that have already been approved. But that process would include the submission of 3 professional references, one of which must be from a certified officer on behalf of that candidate who is applying independently. Now, the regulations also include some additional provisions regarding constables in particular, and those are in boldface in this draft. And again, that's to account for the fact that there are certain differences regarding constables, given that they're normally not employed by law enforcement agencies, and given that the fact that the statute provides for them to be subject to 6E when they execute an arrest for any reason. So to be certified, a constable would need to have a monitor. And that would be either the constable's appointing authority or a law enforcement agency within a municipality where they expect to operate. That monitor would need to agree to serve as such and to be subject to consequences for that. And then the monitor would need to designate one or more individuals who will take personal responsibility for overseeing the constable and taking steps that Chapter 6E normally requires of supervisors. A law enforcement agency or an officer that serves in such a role would be subject to discipline if they did not perform those duties that they've agreed to perform. And a constable who is certified or who executes an arrest would be subject to Chapter 6E's provisions regarding officers and some provisions regarding agencies, as well as commission regulations and policies. So in other words, that is how the provision that states that the statute applies to a constable who executes an arrest for any reason would be implemented. As soon as the constable signals their interest in executing arrests and basically becoming part of the statutory scheme by applying for certification and they get certification, or if that doesn't happen and they execute an arrest anyway, they have then brought themselves within the statutory and regulatory scheme. So that's what that would provide. It further provides that a constable can execute an arrest only if they're certified and they're otherwise lawfully entitled to do so. And if they execute an arrest without certification or otherwise violate any of these provisions that I've just laid out, their certification can be restricted, they could be disciplined, or they could be fined up to $5,000 for each impermissible arrest. And part of the reason why that provision is proposed here is to account for the fact that there could be constables for whom the threat of denial of certification or decertification doesn't go very far, because while the statute provides for a decertified officer to be unable to be employed or appointed by a law enforcement agency, constables, again, work independently of law enforcement agencies normally. So there's a need to include something else in there to ensure compliance. The regulations would further provide that certification does not grant powers beyond those granted by existing law. Now, in addition to those general aspects of these regulations, I'd like to highlight several sections below that I think are worth noting. First is this one that defines arrest. And again, that comes into play in terms of determining which constables are subject to the statute and what it is that constables can and can't do in the way of executing arrests, because Chapter 6E extends to a constable executing an arrest for any reason. So in this definition of arrest, the first sentence is nearly identical to a definition found in Massachusetts case law. There weren't any substantive changes made. In the second sentence takes into account a few different things. And again, that second sentence provides that an arrest includes, but is not limited to, the exercise of a legal remedy or the execution or service of legal process when facilitated by the use or display of a weapon. So that takes into account a few different things. One are judicial decisions that treat the use or display of a weapon as something that militates in favor of an action being found to constitute an arrest at times when that question has been presented to the court, whether something was an arrest in a particular case. It also takes into account the Commission's previously expressed view that the carrying of a weapon should bring a constable within the scope of a statute. And it takes into account the fact that while judicial decisions will often analyze whether an arrest has taken place by looking at the particular circumstances in each individual case, what we really need to have here is a rule that could be applied broadly, that could be applied in advance of any arrest, And that would enable constables to determine whether they would be executing an arrest, whether they would be bringing themselves within the statutory and regulatory scheme. Another possibility would be to add that an arrest includes any service of a habeas warrant or arrest warrant, that alone would constitute an arrest. And I think that there would be a rationale for including that, because when somebody is served with that form of process that restricts their liberty, it subjects them to a legal requirement that is restrictive in a way, but it requires something of them. But at the same time, there are practical considerations there about whether to extend this whole system to those who might just be serving a warrant like that and not engaging in any other form of conduct, such as physically handling the person and physically bringing them to a certain location. So that's something for the commission to consider as a policy matter. We don't expect to ask for a vote on these regulations today, so there's time for that matter and others to be considered, and for other feedback to be provided. But here's another section that I thought was worth highlighting. And this one and another one below provide that if an agency has not determined that an applicant possesses character and fitness, the applicant can only proceed as an independent applicant. In other words, an agency cannot say, we haven't found this person to possess character and fitness, but we're still endorsing them anyway, and then have the commission treat that person as an endorsed applicant. The idea is if they have not been found to possess character and fitness, they need to only apply on behalf of themselves and follow the procedures for people who are applying without agency endorsement. Next is a set of subsections that relate to both, in one case, endorsed applicants, and in another case, independent applicants. But they provide the same thing, which is that an applicant will receive the results of a background check that's conducted and will receive 14 days to respond, the opportunity to do so, before the division determines that an applicant has failed a background check. And that's just to allow for the possibility that there's something in the background check that the applicant perceives to be incorrect or otherwise wants to respond to. It builds in that opportunity. This subsection, it elaborates on something that's included in the recertification regulations. Those regulations provide that the commission can take other steps that are reasonable to collect information on applicants. And this essentially provides suggestions, requesting that the applicant provide additional names or letters from professional references, that the division could, if it so chooses, could take a step that's done in the process of applying for admission to the bar, which is posting a notice concerning the application on a website and inviting members of the public to provide comment on the application within a reasonable period of time. Affording the applicant other opportunities to respond to information or allegations that have surfaced beyond what's expressly included in the regulations. So those are other steps that could possibly be taken. This next subsection would simply enable the division to evaluate certification standards in any order that it deems expedient and to stop after finding one standard unmet. And so it's just a practical addition that would relieve the division of having to undertake the more onerous aspects. So in other words, conducting a background check, conducting an interview, conducting a character fitness assessment, where they already know that that would be futile because, for example, the applicant is under age 21. This next provision would expressly affirm that the completion of required in-service training and retraining is a standard for certification. That's something that'll be discussed at a later part of the meeting. This next section expounds on something that's included in the recertification regulations. They provide that a serving officer is not subject to a condition when there's been a conditional recertification until after the conclusion of review or the time for seeking it. So in other words, the officer doesn't need to satisfy that condition until after the officer has had that opportunity to challenge it. And that's been decided upon. This subsection, it does the same thing with respect to any serving officer who's seeking recertification independently, but where an applicant is seeking initial certification, so somebody who hasn't been serving on the job, it gives the division discretion to decide whether to take that step. And so it's based on the idea that there might be a need for more caution with someone who is not already serving as an officer. So in other words, if somebody is not already serving as an officer, the division might decide that it wouldn't be prudent to say, you can start serving and you will only have to satisfy that condition that we've imposed after the end of your review process. The division would have the latitude to say, no, actually, we're going to require that the condition be satisfied before you can start serving. This next provision would expressly affirm that the failure to honor a limitation or a restriction on certification may be grounds for disciplinary action. That should be clear enough from the statute, but it would expressly affirm that. These next subsections that are highlighted provide that an initial certification does not become effective before the commission, before the individual becomes an officer. And so that's consistent with the idea that the commission certifies officers. So somebody would not, they could receive a decision stating that they will be certified, that they're eligible for certification, but until they actually assume that job, the certification does not officially commence. And this next provision that's highlighted expressly allows the commission to reconsider a certification decision. And lastly, there are two sections at the very end that are in boldface because they concern constables, and they elaborate on things that I covered at the beginning of the presentation, specifically the particular requirements for constables and the monitors that they would need to have in order to be certified under this plan. So if there are any questions, I'm happy to answer them.
Thank you very much. Sorry, I think Commissioner West has a question.
Thank you, Chair. Randy, just quickly on the definition of arrest, in your commentary, you were talking about if the person was serving an arrest warrant or a capious warrant. You're envisioning if they're serving an arrest warrant, they are then taking that person into custody, right?
Well, if they take a person into custody, then it would clearly fall within this definition of arrest. But from what we've heard, and I'll invite anyone else to comment on this, who was in a meeting that we had with representatives of two constable associations, as well as representatives of the MPTC and EOPS. From what we heard, there are times where that warrant will be served, but the constable will not actually physically take the person into custody. They will give that person the opportunity to appear. Again,
Okay.
If anyone, if anyone has anything to add on that subject, because it was the topic of a lot of discussion.
Okay, well, if that's the case, that answers my question. I think if we end up adding language like that, we just need to be clear that it envisions that scenario.
Thank you.
Are there any other questions from the commissioners? I think not. Randy, thank you very much for the comprehensive discussion. And thanks also to all who have worked on these proposed regulations. As you indicated during the presentation, we do not intend today to take a vote on the regulations. So I think with that, let's move on to item number 4B, please, on our agenda, namely the dissemination of information on certified status.
Thank you. I will turn to Deputy
Commissioners.
General Counsel.
Sorry. I'm just going to share my screen. Good morning, Commissioners. At the last commission meeting, the commission began discussions about the release of information for certified officers, so this follows up from that discussion. Before you for your consideration is a proposed authorization to publish on the commission's website a list of certified officers. By certified officers, we are referring to officers who graduated from the academy and who have been granted initial certification by the commission after December 15th, 2021, or officers with the last names beginning with A through H who have been granted full recertification. The proposal therefore does not include officers who were automatically brought into certification pursuant to the session law and have not yet been reviewed for recertification. Our reference to a grant of full recertification means recertification with no limitation, condition, or restriction imposed on the officer's status. So the status of full recertification does not include conditional recertifications or denied recertifications. At this time, the proposal before you concerns specifically the release of the name, employing agency, and certification status of officers falling within this category. And to provide additional information and context to you and the public that may be helpful, I will briefly address 3 areas. The first relates to the relevant provisions of the Commission's enabling statute, Mass General Laws, Chapter 6E. The Commission's authority is set forth in Section 3 of Chapter 6E and includes, but is not limited to, the authority to certify qualified applicants, to publish materials on the Commission, to publish materials the Commission considers appropriate, and to maintain an official internet website for the Commission. Therefore, if the Commission were to conclude that publication of a list of certified officers on its website is appropriate, that could be a reason to authorize such publication. Under Section 4 of Chapter 6E, the Commission is tasked with creating and maintaining a publicly available and searchable database containing records of law enforcement officers, and in doing so, considering the health and safety of officers. While the statute does not specify the type of information that must be included in the public database, again, should the Commission authorize posting a list of certified officers on its website, that may be considered an action consistent with this provision. The second area of information that might be helpful is the application of the public records law. As you already know, the public records law imposes certain obligations on the agency. It creates a presumption that all records received or created by a governmental agency is a public record unless one of the enumerated exemptions applies. And it requires the agency to furnish a copy of any public record or segregable portion of the record within 10 business days of receiving a request. If an agency is unable to provide a record within 10 business days or withholds a record pursuant to an exemption, it must provide a written response to the requester, which can be appealed. Additionally, if the public records law permits an agency to furnish a public record by pointing a requester to its website if the record sought is made available there. If the Commission authorizes the publication of a list of certified officers, it may have an impact on the number of public records requests submitted to the Commission, and also streamline the process of responding to these requests by pointing requesters to the website. Finally, at the last Commission meeting, there were some questions raised around steps staff has taken to ensure the information and data we have are accurate. As with any database containing a large volume of information and data, it's difficult or impossible to reach 100% accuracy. However, the Division of Certifications has worked very closely and on a consistent basis with both chiefs of law enforcement agencies and the Municipal Police Training Committee, or the MPTC, to review, validate, and reconcile its list of certified officers. This is an ongoing process, and we're in constant communication with agencies and with the MPTC. Additionally, publishing a list of certified officers may also have the added effect of improving the quality and accuracy of the Commission's data by providing another opportunity to officers and their chiefs to report errors. I hope you find some of this helpful in your consideration of the matter. And with that, I'll turn it back to the chair.
Thank you very much, Pauline. Do you want to just end the screen sharing, please?
Sure.
This is an issue that we have addressed in the past. I wonder if there are any questions as to the presentation, the materials that have just been provided to the public by Pauline. If not, I would entertain a motion at this time to authorize Post to publish a list of certified officers on the commission's website. Is there such a motion?
So moved.
So moved.
Is there a second to that motion?
I second.
Second.
Any further discussion? If not, let me call for a vote. Commissioner Bluestone, please.
I approve.
Commissioner Calderon,
No, I'm against.
Commissioner Sherry,
I approve.
Commissioner Ellison,
Yes.
Commissioner Kajirosian,
Approve.
Commissioner Luma,
Approved.
Commissioner West,
Approve.
Commissioner Wynn,
Yes.
and I also approve. With that, the motion is carried. Let me now please move on to the next item on the agenda, listed as item 4C, namely the delegation of authority for immediate and administrative suspensions. Please, General Counsel Ravitz again.
I will again turn things over to Deputy General Counsel Wynn.
Thank you. Good morning, commissioners. Again, this next issue for your consideration concerns a delegation of authority and an adoption of certain requirements and exemptions related to in-service training. The specific delegation sought here is a delegation to the executive director or the executive director's designee the authority to issue 3 specific types of suspensions of law enforcement officer certification provided by sections 9A1, 9B, and 9C of Chapter 60. Under Section 9A1, the commission, quote, shall immediately suspend the certification of any officer who is arrested, charged, or indicted for a felony. Sections 9B and 9C contain provisions for administrative suspensions to be issued under specific circumstances and only until certain conditions are met. Under Section 9B, the commission is required to administratively suspend the certification of an officer who fails to complete the commission's in-service training requirements by a certain deadline, and the suspension remains effective until completion of the commission's in-service training requirements. Under Section 9C, the commission is required to administratively suspend an officer's certification if the officer fails to report certain alleged misconduct to the commission pursuant to Section 8, and the suspension remains effective until the completion of said report. These 3 types of suspensions may be issued without regard to whether a preliminary inquiry has been initiated and without a prior hearing. To the extent the statute appears to contemplate that each suspension will be issued by the body of 9 commissioners, it is staff's recommendation that the executive director or his designee possess authority to issue and effectuate these 3 types of suspensions for several reasons that I will touch on briefly. First, the commission would be able to act more promptly as required and intended by the statute. These 3 forms of suspensions mandate the commission to act immediately or without significant delay. Second, the delegation of authority to the executive director may promote administrative efficiency. The 3 statutory provisions require that the commission respond automatically upon the occurrence of a set of circumstances listed, leaving no room for the commission to evaluate different options and decide among them. Therefore, the issuance of a suspension under one of these 3 sections could be viewed as ministerial in nature, not involving an exercise of judgment and discretion. A delegation would obviate the need for the commission to convene on these suspensions only to engage in a ministerial act that will require little to no deliberation or discussion. And third, The executive director's action would be subject to review. The procedures associated with these suspensions entitles the officer to a hearing before a single commissioner within 15 days. In addition to a delegation, staff recommends that the commission clarify certain matters regarding administrative suspensions based on failures to complete in-service training under Section 9B. The statute refers to the commission's in-service training requirements and deadlines and provides that the commission may promulgate reasonable exemptions to Section 9B, including but not limited to exemptions for injury or physical disability, a leave of absence, or other documented hardship. So for purposes of 9B, it would promote clarity and consistency for the commission to affirm that it adopts the MPTC's in-service training requirements and deadlines, as well as the in-service training exemptions that the commission previously recognized in its certification policies. As a point of clarification, I just want to note that these exemptions do not provide an exemption from the training itself, but are exemptions from the administrative suspension provision in Section 9B. And even then, an exemption from a Section 9B suspension is temporary and effective only during any extension granted. If an individual fails to satisfy all training requirements before the expiration of an extension, the previously granted temporary exemption will end, and the individual must be subject to the administrative suspension provisions of 9B. In sum, staff is seeking an express delegation of authority to the executive director or the executive director's designee to issue suspensions of a law enforcement officer's certification under M.G.L.C. 6E sections 9A1, 9B, or 9C, and the adoption of the requirements and deadlines for in-service trainings established by the MPTC as the requirements and deadlines of the commission, and adoption of the exemptions that the commission previously approved in policies regarding recertification for purposes of suspensions under 9B. And with that, I will now turn it over to the chair.
Thank you again, Pauline, for that presentation. Let me ask whether there are questions or comments at this point. Commissioner Calderon, yes, sorry. Yes, Commissioner Calderon, please.
Thank you. So I have a question. I understand number 1 and 2, but in number 3, I guess I'm looking for clarification. I'm a little bit confused. It mentions subsection 8. It talks about the commission shall administratively suspend. But I believe that there's a preliminary inquiry when you go to section 9C. So I guess maybe if we could talk about or get a more in-depth explanation of number 3 as it pertains to the subsection in 8 and the completion of the report. Are we talking about the chief or the commissioner of the department, or are we talking about the officer? That's what I'm confused on.
We're talking about the requirement to report certain alleged misconduct to the commission that is provided in section 8. And so that essentially means filing a complaint with the commission or reporting certain types of conduct to the commission as required. So upon receiving information that an agency has not reported certain types of misconduct to the post commission, the post commission can take action through an administrative suspension of a particular officer or a particular chief if they have failed to make such a report.
So you're saying, I just want to make sure that I'm right. So you're saying the agency has a duty to report this. So I'm failing to see why we would take the onus away from the commission or the responsibility of the commission to interpret the shall or the may in section 9 and have one person make that decision based upon the agency. I guess I don't understand how it's going to work. If we were to grant the executive director the capability to administratively suspend, well, how is the officer getting suspended, or why is the officer getting suspended if the chief or the commissioner of the department hasn't done their job? It doesn't seem reasonable to me.
Yes,
If I may-
Enrique.
Yeah, if I may, Commissioner, I think in the scenario that you seem to be sketching, Commissioner, it would be the person who failed to report certain things. So if it's a chief who failed to report, then the chief would be the one suspended.
And that's what I was getting at, Mr. Director. It seemed to me that the answer given, and again, I don't know if I'm saying it correct. It seemed the answer given is it is the agency's responsibility according to the statute. So it would only be the chief or in Boston, the police commissioner. The officer, him or herself, are not affected by this, correct?
I agree, and I see Counsel Ravitz nodding as well.
I didn't want to say that, but yeah, I did see that. Am I correct, Randy, in what we're saying and what the ED is saying?
Yes, if somebody has a duty under Section 8 to make a report, and that person who's supposed to make the report, which, as you say, is normally a supervisor, and they don't make the report, then the statute says that that person shall be administratively suspended until they make the report. And then once they make it, it's lifted.
Okay. Okay, I understand that. I appreciate the clarification because I was really stuck on it, as you could see. Maybe somebody could also answer this if I could continue. Is it okay if I continue with the second one, Chair?
Yes.
So in section 9, it talks about the commission may, after a preliminary inquiry pursuant to the above paragraphs, suspend for a misdemeanor. So I guess the direct question is, do we intend as a commission, or better yet, is this asking to give the ability, instead of the commission, give to the executive director the ability to make the decision based on a misdemeanor for an officer? Or is it a misdemeanor again for the chief of the department? Is it still the chief, Rent? I don't know who wants to answer that. Is it still the chief we're referring to in a misdemeanor, or are we talking about a police officer?
In that case, that provision is talking about the officer who is suspected of committing a misdemeanor.
Okay, sorry, go ahead, Mr. ED. Yeah.
Sorry, but I don't believe we're asking for that delegation, Commissioner, because in the case of misdemeanors, the statute is permissive about the suspension. It says a may as opposed to a shall. Because in section 9A1, it says a shall, as Pauline mentioned, this is ministerial and we can act expeditiously. But where the statute is permissive, we're not delegating that. That would effectively remain within your authority, commissioners.
So is Mr. Director, is there a way to amend the language to make sure that it's clear that it's only pertaining to the supervisor or the chief and not the secondary? If there's a way to word that, I'm in support, of course.
I'm sure that could be clarified, right, Randy or Pauline? We could clarify that it's the person whose duty it is to make the report in the section that was previously.
I'm sorry.
The reason I ask it this way, Randy, is we're asking the commission to give the authority that's granted to the commission under the statute to the executive director. I just want to make sure it's clear only for the chief in this case.
Right. If we're still talking about that 9A1, or excuse me, I apologize.
9C.
9C. Thank you.
Yes.
That deals with the failure to make a report under Section 8. Section 8 refers to the head of the agency. So that would be the person who would be subject to that kind of suspension. And so it sounds like, Commissioner, you're proposing to work that in specifically, right? That a reference to the head of the agency?
Yes, sir. Down in number 3 of what we're being asked at some point, I don't know if it's today, but we're going to be asked to vote on some point, number 3, 6E subsection 9C. If we could just put another line to make sure that it's specific to the head of the agency, I think that's important to point out. So later, if we're going back and looking at something that we passed in one of these meetings, we'll have verification as to what the actual meaning was for the vote that we take.
Let me suggest, Commissioner, that we say, if you want to word the motion like that, that we say that it's the head of the agency or their designee, because there are large agencies, sir, that may have the superintendent or a captain, I don't know, in charge of that duty. And we want to allow for that possibility.
That makes complete sense. Absolutely. All right. I appreciate the time. Thank you. And the answers.
And I think Commissioner Ellison, you have some questions.
Yeah, I think they kind of answered it in that last, because my concern was because Boston's commissioner is a civilian and every other chief is a sworn person who would be under the same rules of the post, that wouldn't comply any suspension to like the Boston Police Commissioner. So the language, I think, is important that it also includes the head of the department or the designate, whoever is making that decision about the suspension of the officer or the placement of the suspension of that individual.
Enrique
Commissioner,
or Randy, do you have any further comments? I had a little difficulty, Commissioner Ellison, hearing you at the end of your comments. I don't know whether any of the other commissioners did.
So I guess I don't know if this the language doesn't cover Boston is the only one that has a civilian who is the head of the agency, that the language include that so that we cover the Boston commissioner as well.
I think because 9C says an officer with a duty to report under Section 8, if the commissioner were to delegate that, to require that report to be made by someone under the commissioner's direction, then one way of reading the statute is that then that person would have the duty to report. Now, as far as the commissioner itself, if a commissioner is a civilian, there's no certification to suspend, but somebody who takes on the duty to report and then doesn't do it, you could read the statute to require the suspension of that person. Is that helpful?
Okay, thanks.
So Enrique and Randy, I think your intention was that we would move on this particular issue today, seeking approval. I guess my comment is, are we in a position to do that given Commissioner Calderon and Ellison's comments, or ought we to wait until our next meeting to get that clarification? And maybe this is a question also, I should include Pauline in that.
my recommendation is that if any commissioner is prepared to make such a motion with the amended language, to allow for that clarification that Commissioner Calderon wanted, I would rather you take that up today, commissioners. There's plenty of business ahead of us.
All right.
I'm happy to make the motion. But I don't want to misstate the corrected language.
And perhaps before we have that motion, at the moment, I think I see two hands in the air. First, Commissioner Bluestone, and then Commissioner Calderon again, please.
Thank you, Chair. I just have a question because I think this is a really interesting point. And I'm wondering about, where it says that the commission shall administratively suspend the certification of an officer with a duty to report. Is there urgency around that? It sounds, the language is different to the immediately suspending of an officer with a felony charge, but is there sort of any sense of what that means in terms of a time frame?
You know, Commissioner, that's another alternative. Perhaps what you're suggesting, that the delegation be only limited to 9A, 9A1 and 9B, because that's clearly the immediacy ones. And in a scenario where we find that there was a failure to report, it presumes that there's a lot more time frame for us to do that, and we could perhaps come back to the commissioners if you so chose for those eventualities. Is that the question
I
you were
think-
trying to?
Yes, because I think that, you know, as Commissioner Calderon points out, this is talking about a high level, you know, potentially a high level officer with an authority position. And so I'm wondering if there's the same urgency to do that quickly, and if it might be better for that particular issue to come before the commission.
Any other questions or comments with regard to that suggested modification, I think, by Commissioner Bluestone? And I don't know, Commissioner Calderon, I think you had your hand in the air a moment ago. I don't know whether it was in regard to that or whether it was something else.
Thank you, Chair. No, it was just, it was not pertaining to what Commissioner Bluestone just said. I was just hoping that Commissioner Kazarojian would allow me to put forth the motion to amend, seeing that it was my language. I didn't know if she wanted me to do that or if she was going to do it from her side, but I'm prepared to make an amendment to the motion and move it forward if that's what the body wants to do.
Commissioner, yes.
That's fine, Commissioner Calderon. I would prefer that. I think you have a better handle on it. And I did want to just make sure I understood this too. C is a little different, I think, from the other suspensions in the under A, because it's an administrative suspension, correct? So there's just, we have the administrative suspension, and then there's an action that can be taken immediately to dispose of the suspension. So I just wanted to make sure I understood that too. Okay.
So I think with that, Commissioner Calderon, you've indicated an interest in making a motion. So would you please do so?
Thank you, Madam Chair. Yes, I'll make the motion to amend number 3 of the original motion just by adding in language to clarify that 9C in this instance that we're passing should say the head of the agency, the designee, or the supervisor in charge. I think that should handle it. So that would be my motion. Randy can correct me if there's something I said wrong legally.
Thank you, Commissioner Calderon. Is there a second to his motion?
I second it.
Is there any further discussion? If not, let me call for a vote, please. Commissioner Bluestone,
I approve.
Commissioner Sherry,
Yes.
Commissioner Ellison,
Yes.
and Commissioner Luma.
Approved.
I'm sorry. Did you say-
Sorry, approved.
Thank you. Commissioner West,
Approved.
Commissioner Wynn,
Approved.
and both the moving party and the second I have not called on because they approve. I also approve. So with that, the motion is carried unanimously. Again, thank everybody for your comments. Those of you who have worked on this issue, we are grateful for that. And I think with that, commissioners, we move on to item number 5 on the agenda, matters not anticipated by the chair at the time of posting. Let me say that there are no such matters. And at this point, I will now, commissioners, entertain a motion to go into executive session to discuss requests by the Division of Police Standards of the Post Commission to approve conducting preliminary inquiries in matters labeled PI 2022-11-22, 1 through 6, and recommendations by the Division of Police Standards to suspend the certification of individuals in matters labeled 22001 through 009. Our executive session on this issue will be held under various provisions of the general laws, which include Chapter 38, Section 21(5), because it is anticipated that there may be discussion regarding in the executive session investigation of charges of criminal misconduct, as well as Section 21(7) of Chapter 38, combined with Chapter 60, Sections 8C2, and to the extent that they may be applicable, Chapter 6, Sections 168 and 178, because it is anticipated that there may be discussion during the executive session regarding the initiation of preliminary inquiries and initial staff review regarding the same, and also regarding certain criminal offender record information. A majority vote, commissioners, by roll call is required to go into executive session. May I ask for such a vote? Commissioner Bluestone,
I approve.
Commissioner Calderon,
Yes, I approve.
Commissioner Sherry,
I approve.
Commissioner Ellison, Commissioner Keserosian,
Approved.
Commissioner Luma,
Approved.
Commissioner West,
Approved.
Commissioner Wynn.
Approved.
I also approve, so the request to go into executive session, the motion is allowed unanimously. And let me say to the members of the public that the open session will not reconvene at the conclusion of our executive session. I thank the members of the public who have attended the meeting. I thank the members of the staff who have done such thorough and diligent work on all the matters that we've addressed today. I thank the commissioners for their comments and questions and their participation in the process. With that, the open meeting will conclude. We will begin our executive session in approximately 5 minutes. Members of the commission and those who will be attending the executive session. Is there anything else that we should address at this point? Randy, anything further at this point? I think with that, we will leave the open meeting. Again, thanks to everyone who has participated in any manner. We will reconvene in approximately 5 minutes in the executive session.
Thank you.